Okay, this is some warm-up for the record. Now, malice is a term of art importing wickedness and hatred and a determination to do what one then knows to be wrong and without just cause or excuse or legal provocation. Now, malice need not be in the mind of the one doing the killing for any particular length of time before the act of killing in order to render the killing murder. If it is present in the mind for any length of time before the act and at the time of the act, accompanying and prompting the act, then its presence would be sufficient to render the killing of a human being murder. Now, malice is said to be expressed where there is manifested a violent, deliberate intention to unlawfully take away the life of a human being, where one says he or she is going to do it or does it. Malice is implied from the use of a deadly weapon. Now, where there are circumstances attending a killing showing an abandoned heart, a malignant heart, fatally bent on mischief, if the evidence shows under what circumstances a shot was fired or a blow was struck, which took the life of another, then the jury will have to determine whether, under such circumstances, the act was malicious or not. Let me repeat that. Now, malice is a term of art importing wickedness and hatred and a determination to do what one then knows to be wrong and without just cause or excuse or legal provocation. Now, malice need not be in the mind of the one doing the killing for any particular length of time before the act of the killing in order to render the killing murder. If it is present in the mind any length of time before the act and at the time of the act, accompanying and prompting the act, then its presence would be sufficient to render the killing of a human being murder. Now, malice is said to be expressed where there is manifested a violent, deliberate intention to unlawfully take away the life of human being, where one says he or she is going to do it or does it. Malice is implied from the use of a deadly weapon. Now, where there are circumstances attending a killing showing an abandoned heart, a malignant heart, fatally bent on mischief, if the evidence shows under what circumstances a shot was fired or a blow struck which took the life of another, then the jury will have to determine whether under such circumstances the act was malicious or not. Okay, this will be some legal material for the record. Mr. Foreman and ladies and gentlemen of the jury, you have heard all of the testimony in these cases. You have heard the arguments or the summations of the attorneys. It now becomes my duty to state to you the law that applies to cases of this type. It is your duty to make a determination of the facts in the case. It is for you to decide or determine just what did or did not happen. You apply those facts as you find them to be to the law, as I shall state it to you, and thereby arrive at a proper verdict. Now, under the laws of our state, I am not permitted to comment upon the facts in the case. You, the jurors, are the sole and exclusive judges of the facts in each case. The facts are for your consideration. The facts are for your determination. I am satisfied that you are fully capable of determining them. As I have just stated to you, it is my duty under the laws to state to you the law that is applicable to the case in order that you may apply the facts as you find them to be and render a proper verdict. It would be a violation of your duty to attempt to determine the law or to base a verdict upon any other view of the law than that given to you by the court, a wrong for which the parties would have no remedy, because it is conclusively presumed by this court and by all higher courts that you have acted with these instructions as you have been sworn to do. So, Mr. Foreman and ladies and gentlemen of the jury, you are here for the purpose of trying the issues of fact presented by the allegations in the indictments and the plea of not guilty of each of the defendants. This duty you should perform uninfluenced by pity for the defendants or any one of them, or by passion or prejudice on account of the nature of the charges against them. You are to be governed, therefore, solely by the evidence introduced in this trial and the law as given to you by the court. The law does not permit jurors to be governed by mere sentiment, conjecture, sympathy, passion, or prejudice, public opinion, or public feeling. Both the state and the defendants have a right to demand, and they do so demand and expect, that you will carefully and dispassionately weigh and consider the evidence and the law of the case, and give to each your conscientious judgment, that you will reach a verdict that will be just to both sides, regardless of what the consequences may be. Okay, this is some literary warm-up for the record. Mr. President, domestic violence is a serious and widespread problem. In many homes across this nation, the wealthiest as well as the poorest, there are persons who beat, batter, and abuse their spouses, children, and elderly parents. This is not a new phenomenon by any means, but it is one which has come to public attention in recent years. I should like to share with my colleagues some of the things I have learned from hearings I have chaired over the past 2 years before the Subcommittee on Child and Human Development. One of the first national studies on the problem of domestic violence was conducted in 1976 by Professors Strauss, Steinmetz, and Gellis. They conducted a national survey of 2,143 randomly selected couples. The results of the study showed that of the approximate 47 million couples living together in the United States in 1975, over 1.7 million had faced a husband or wife wielding a knife or gun. Well over 2 million had been beaten by their spouse, and another 2.5 million had engaged in high-risk injury violence. Mr. President, approximately 1/4 of all murders in the United States occur within the family, and approximately 1/2 of these are husband and wife killings. In my own state of California, 1 of 3 female homicide victims is murdered by her spouse. Another sad and frightening aspect of domestic violence is the tremendously high frequency of batterings suffered by pregnant women. One study found that 1/4 of women who were beaten while pregnant. In recent years, we have become increasingly concerned about crime in the streets and the extreme dangers faced by law enforcement personnel. But we seldom focus on the danger faced by police officers in domestic violence situations. A study conducted in Chicago found that over a 2-year period, 21% of police officers killed in the line of duty were killed when responding to domestic disputes. FBI statistics show that out of 5 officers killed in the line of duty died trying to break up a family fight, and 40% of police injuries occur in the same way. Mr. President, in the nearby county of Fairfax, Virginia, the police received 4,073 family disturbance calls in a single year. Here in the District of Columbia, the Citizens Complaint Center receives between 7,500 and 10,000 complaints of marital violence each year. According to a 1979 New York Times report, marital violence accounts for 82% of all aggravated assaults in New York City. A 1979 Lewis Harris survey in Kentucky yielded results that I personally find astonishing. That survey found that 10% of the wives interviewed had been involved in an abusive incident with their husbands during the 12-month period prior to the survey, and that during that same 12-month period, only 2% of all the women interviewed reported physical assaults outside their home. These results would seem to indicate that the most dangerous place for a woman to be is not in the street, but in her own home. Mr. President, another facet of the domestic violence problem, elder abuse, is one which only recently has been brought to public attention.